Our thanks go out to Cindy and Bruce for their wonderful and insightful opening remarks. My name is Natasha Vernon, and I'm the Manager of Dispute Resolution Services at CPR. If you have any questions about case handling or about case administration, please reach out to me. Most recently, I have been involved in implementing CPR's diversity pledge and in making sure that diverse candidates make up at least 30% of the candidates in nearly every slate that we send out to parties and their attorneys. This morning, I am very pleased to present the first panel discussion titled Creating Leverage, How Technology Companies Can Use Investment Treaties to Mitigate Regulatory Risk. This panel will be moderated by Thomas Walsh of Freshfields. Thomas is special counsel in the firm's US-based International Arbitration Practice Group. In his practice, he focuses on complex arbitration as well as litigation matters. He has served as counsel in numerous arbitrations under most of the major arbitration rules, as well as in litigation matters in both federal and state courts. Besides serving as counsel during arbitration, Thomas himself is an arbitrator in commercial disputes. Most interestingly, prior to practicing law, Thomas was a Fulbright Scholar in Ecuador for 3 years. We thank Thomas for participating and for bringing all of his varied and deep experience to enhance the panel today. This panel promises to provide a unique perspective on international disputes and investment treaty arbitration. Thomas, the floor is yours.
Well, thank you for the kind introduction. It was more grandiose than I necessarily expected, but much appreciated. So as our moderator indicated, excuse me, the title of this panel is Creating Leverage, How Technology Companies Can Use Investment Treaties to Mitigate Regulatory Risk. We have an excellent panel. Before we dig into the substance, I'd like to give them the opportunity to introduce themselves. Annie, I'm looking in your direction. Will you kick us off, please?
I'd be happy to. Thanks, Tom. Thanks to you and the CPR for this invitation. I see many Canadian and American friends in the attendees, and so I'm absolutely delighted to be amongst you today. My name is Annie L'Espérance. I am based in Montreal, Canada. I'm an investment manager and legal counsel at Omni Bridgeway, a leading dispute funder. In that capacity, I am responsible for sourcing and assessing investments in investor state and commercial arbitration and litigation matters, with a particular focus on Latin America, as I'm the head of Omni Bridgeway's Latin America group. I work closely with claimants to structure funding deals that address their unique needs. And I'm a trained lawyer and have dedicated my practice to international arbitration, having previously worked at the Permanent Court of Arbitration in The Hague, and with Yves Fortier, Canada's former ambassador to the United Nations and a leading arbitrator.
Leon, could you take a moment to introduce yourself?
Yes. Hi, good morning, everyone. My name is Leon Skornicki. I am Senior Managing Counsel at Visa Inc. And before Visa, I used to work in private practice, and I worked at Freshfields, Tom's law firm, for a few years. I did disputes before joining Visa. I was involved in several investor state disputes, representing both claimants and states. Also did commercial disputes. And then at Visa, I switched gears and I am a general counsel of a business unit that does business in Central America and the Caribbean, including the US territories there, and some other sphere. I also have some other legal responsibilities in Latin America and the Caribbean. And I am very happy to join you guys, and Tom and the team at CPR. Thank you so much for the invitation to share some thoughts.
Thanks, Leon. And Carlos, could you round us out?
Good morning, all. I'm Carlos Concepcion. I am the chair of the International Arbitration Practice Group for Stricardi and Bacon. I am based in Miami, although, of course, as we all know, we're all based virtually these days, although we hope that we're not going to change pretty soon. I'm in Miami most of the time, DC, New York, but our practice group and primarily what we do, especially out of the Miami office, is represent claimants in investor state arbitration matters, typically against sovereigns in LATAM. And that is essentially the focus of our practice. We do a lot of commercial arbitration also. And of course, a bit federal court old-fashioned litigation work. But most of our bread and butter work is investor state arbitration work on behalf of the claimants. Thank you.
Thank you, Carlos. We had a fourth panelist, Kristen Bauer, who is legal advisor at the U.S. Department of Commerce. Due to current events, which we can all read about on the front page of the newspaper, she had unexpected travel plans and is now in Central Asia, I believe. And so we'll wish her well and see her at the next conference. Well, I hope everyone's been enjoying the conference so far. We're honored to have the first panel. We're going to use a Q&A format rather than PowerPoint. If you have any questions as you go, please pop them in the chat function and we'll address as many as we can. And perhaps at the end, we'll have some time for live Q&A as well. So the purpose of today's panel is to discuss how technology companies can use investment treaties to defend themselves against unwarranted regulatory actions. I'll give a brief intro and then we'll turn it over to our panelists. As I think we all know, the tech sector is increasingly drawing the attention of foreign regulators. You can see this in the newspaper each day. There are numerous examples of this attention. To give a few, there's the introduction of data localization regulations, new tax regimes, and then other laws that affect the entire sector, as well as more targeted actions such as antitrust scrutiny, cancellation of concessions, and the banning of certain apps. So there are plenty of opportunities for tech companies to be in disputes with their host country regulators. In some cases, these actions by these regulators are perhaps appropriate, other times not. But in any event, tech companies are not without tools to push back. And we're going to talk about one of those tools, and that would be investment treaties, and particularly the right to bring claims for violations of those treaties in international arbitration outside the local courts of the host government. So even just the potential of bringing a claim can provide meaningful leverage in negotiations with governments. That's something I'd like to focus on because we're really here today to talk about dispute prevention rather than actually litigating against the state. So certain sectors such as oil and gas and traditional infrastructure have long used investment treaties for just this purpose. It's resulted in hundreds of claims against states, however, even more threatened claims that never had to be brought. And we're now seeing tech companies adopting that strategy as well. And so our panelists will take us through some of the key considerations on how tech companies can use investment treaties. And I'll turn first to Carlos. Carlos, could you talk to us a little bit about some of the fundamentals, particularly what are investment treaties and how do they protect foreign investors?
Thank you, Tom. A bilateral investment treaty or a multilateral investment treaty is an agreement or treaty between the contracting states. And again, a contracting state, of course, is a state that has signed up for the the bilateral investment treaty or the multilateral investment treaty. And it establishes, the BIT does, the terms and conditions pursuant to which investors of one contracting state can do business in the contracting state of their choice, provided, of course, that they sign up for the treaty. So it is a robust network of treaties that we have. I think at my last count, we have about 3,000 of these bilateral investment or multilateral investment treaties in about 180 countries. And one of the fundamentals is, why is it that states sign up for these things? Why do they exist? And a lot of studies have shown that, particularly with respect to countries that are developing in nature, there is a very strong correlation between the execution of these bilateral investment treaties and the rise of foreign direct investments. So it's a tool that is used by a lot of countries, a lot of contracting states to attract investors. And of course, investors, are interested in doing business in many of these developing countries, and frankly, a lot of the non-developing countries. The United States is one of them, signatories to many of these BITs, because of course they want their investment to be protected. They want to make sure that they have a fair opportunity to vent their disputes and to negotiate their claims that they may have. And that brings me to the fundamental bedrock principle of why it is that these investors like these bilateral investment treaties so much, as opposed to litigation matters, is that these treaties call for arbitration. Typically in ICSID, International Center for the Settlement of Investment Disputes, and they manage and administer these international claims, as opposed to having to forcing the investors to vet their claims or litigate their claims in the local courts. And that is, again, I think probably the most important hallmark of these bilateral investment treaties. And it forms the basis pursuant to which you can set forth a mechanism to negotiate, mediate. There's a mediation mechanism also to promoted and sponsored by ICSID. And so those are the fundamentals of these BITs. I don't know how much more time you want me to talk about this, Tom. I have some thoughts on what I call we'll call them causes of action for those that grew up in common law litigation context, but these treaty-based claims or disputes or causes of action that typically can be used to bring claims against states. So should I talk about that a bit, Tom, or do you want to move on to another question?
Well, I was going to come back to you later and ask you about some of the typical causes of action.
Okay.
So why don't we save it for a moment?
Okay.
But thank you for laying out the fundamentals and the fact that there is this great network of investment treaties providing these protections to investors, including the right to bring claims outside local courts and in international arbitration. I was then going to ask Kristen, who is of course not with us, to talk a little bit about how you get these protections. Who qualifies as a protected investor and what qualifies as a protected investment. In her absence, I'll pick up my own question. And the answer is fundamentally the text of the treaties tell us what is protected and who is protected. They vary, of course, treaty to treaty, but there is some common ground that you typically find in these treaties. And typically the definition of investor is quite broad. They protect companies incorporated in one of the parties to the treaty that invests in the other party. So if you are a U.S. corporation investing in Argentina, you are likely protected under the U.S.-Argentina bilateral investment treaty. And a qualifying investor can, in principle, be really any type of corporate entity, including a special purpose vehicle. Though you do have to be careful with the text of the treaties. Some will require not simply incorporation in the home country, but also some level of business activity in the home country, though that can often be easily satisfied by showing offices and employees, board meetings, things that typically companies are undertaking in their home countries. And one other critical point that I want to highlight is that you need to be this protected investor before your dispute arises. And so if you're structuring your investment, please do so before your dispute arises. Once it arises, you cannot restructure to obtain those treaty protections. But fortunately, structuring for treaty protections is relatively simple. It's something that many companies do at the same time that they're thinking about their tax structuring. And certainly when we advise clients on treaty structuring, we often do it hand in hand with tax colleagues. Now, if that's the definition of the investor, what investments are protected? Again, typically a very broad definition that you'll find in investment treaties. They typically define protected investments to include effectively, quote, every kind of investment or asset of value, and then give a non-exhaustive list of covered investments. And those lists typically include things like tangible and intangible property, shares in local companies, contractual rights, including concession agreements, permits to operate, and IP. So many of the assets that tech companies have in the jurisdictions where they invest. And needless to say, this is a broad definition. There typically are some territorial limitations, and that's important. That being that the investment needs to be at least in part in the host country. And the caveat being that some of the investment can be outside provided that the benefit of the investment is felt in the host country. So to give you an example, your servers may be located in the United States, but perhaps they're serving a business in Mexico. That would potentially be covered as an investment in Mexico. So the fundamental issue is that you need to look at your treaty and do your analysis of whether you're protected and whether your investment is protected. But typically those treaties define both protected investor and investments quite broadly. So with that, I think we've laid some of the basic groundwork. And Leon, I'd like to turn to you and discuss for a moment how investors can use investment treaties to mitigate their regulatory risk. We've talked about the fact that treaties provide this opportunity to bring claims in arbitration. How do companies take advantage of that leverage point?
Sure. So before I begin, I should say that Visa is a CPR member, and Visa blessed my participation in this panel. But I do have to disclaim that what I'm going to share today is my personal opinion and not necessarily that of my employer. So, Tom, to your question, so how do tech companies use treaties to mitigate regulatory risk? I would say that, while being a very broad topic, I'd like to share with you 3 areas that you really would apply to most companies, tech or no tech. And then I'll do some call outs that may be of particular interest to tech companies. So the 3 areas that I would say is, number 1 is escalation, number 2 is leverage, and number 3 is forum selection or neutrality. And that last one really is if all else fails, right? So the regulation may be already in place, and the only way to mitigate it is to actually have some sort of dispute, formal dispute. So on escalation, there's 2 types of escalation that I'd like to call out. So one is that the threat of using a treaty dispute, or the actual use of it, can get the attention of the right person. So you can escalate a dispute to the right government official that may have the power or authority to actually resolve your dispute, or at least take a concrete position. So that I liken it to, in a commercial agreement, these multi-step dispute resolution clauses, where the first step is you actually call the people in each company that have the authority to resolve a dispute, where in government, it can be even more power and decision-making can be even more diffuse. So actually bringing forth the threat of a treaty claim could actually land your dispute in the right office or with the right official. And that is particularly, I think, important for tech companies that use some sort of SaaS model or that deliver services via the internet, because companies may not have a physical presence in each one of the countries where they're delivering their services. So they may not have a direct line of communication with the government that you built over the course of several years, and you have some trust. So maybe your first real interaction with the government where you're wronged and you want to have this issue, this regulation resolved in your favor. So bringing forth a treaty claim can get you at least into the door of the right person that can help you in the government to hear your case. The second escalation point is that these treaties have the particular effect of making any form of regulation in the country, whether it's local, provincial, or state, or national, sort of federal, be resolved by the same sort of people in government. So the national government, when they sign one of these treaties, they are basically assuming responsibility for regulation at all levels of government. So if your dispute is really in a city, so controlled, let's say, by a mayor, or in a state where the governor is the decision maker, but you're not really getting a fair opportunity to plead your case with that person, a treaty dispute or the threat can elevate that dispute to the highest level possible in government, where a minister or a president may be the one actually hearing your claim. Presidents, I would say, usually don't, but maybe it's the Attorney General or whatever office at the highest level is prepared to deal with these treaties. And those officials tend to have a very different outlook on foreign commerce and on foreign direct investment than does, say, a local government official. So the second point on how to think about mitigating is leverage. So these treaties can basically give you a few forms of leverage. One is sort of the typical thing the typical argument that you would use in law in most cases of slippery slope, right? So if government, you insist in going down this road and you are taking this action towards me, what is that going to say about you to other foreign investors, to future investors, or to maybe existing investors that are in my same position? So it can give you leverage because it can also call to everyone's attention and maybe spook future investors or galvanize existing investors against a country or against any regulation. The other one on leverage is publicity. So typically disputes with government, depending on the importance and the brand name behind the company, they could be receiving some publicity. But typically local press will be very interested in these cases because they are very rare. There's some countries that are repeat offenders, but for the most part, they're fairly rare and they're quite interesting because it's an interesting mix between politics and law, and you have the business aspect behind it. So you could get publicity, that could be good or bad, but for the most part, you could try to use it to your advantage. And the other one related to publicity on leverage is you can get the attention of foreign organizations or international organizations that could help you lobby the government in your favor. So the UN or the World Bank hosts one of the major institutions where you would go and plead your case, ICSID, or an organization like the OECD. All of these three organizations have people in their staff whose job it is to monitor foreign investment treaty claims, and they are fairly specialized and oftentimes have very strong opinions about how a government should conduct themselves if faced with one of these. And the last one that I'll point out is on leverage is precedent. So these cases for international treaty arbitration, there is no precedent. There is no common law in theory of these cases. Now, in practice, arbitrators, when they're deciding a case, will look at what happened under other cases under the same treaty or similar claims under different treaties that have more or less the same wording. So you would usually make arguments to the arbitrators looking back at what has happened in previous decisions of other arbitration tribunals. So that going forward can also have the effect of, if you mitigate a regulation in a particular country, in that country in the future, you can say, well, let's make sure, government, that you aren't taking similar regulatory action in the future because you can get the same result. And also precedent in the sense of other countries taking similar regulatory action may look back at a case with a neighboring country and say, well, we shouldn't take this course of action because of XYZ decision that another country faced in a similar matter. So those are a few things that can give you leverage in the case. And the call out for tech companies in terms of leverage is that these treaties aren't open to big companies only. They're open to any investor that qualifies and that has a qualifying investment in the host country. So big companies and small companies alike would potentially be able to use these claims or threat thereof. And others will talk later in the panel about the costs of these arbitrations or these proceedings, and how you can actually deal with those costs, even if you're a small company. The last thing that I'll share with you, very brief, is if all else fails, a benefit of these treaty claims is that you can access a form of forum neutrality, where instead of going to domestic dispute resolution processes, whether it's domestic litigation or domestic administrative proceedings, or maybe even having to lobby legislative powers in the country, you take that dispute and you take it out of the domestic realm entirely and go before a tribunal that is supranational, that is independent from the government and not beholden to it. And so in theory, you should be getting an impartial set of eyes to evaluate your situation. So with that, Tom, I'll give it back to you.
Well, thank you, Leon. And I like your various leverage points. I'd like to talk a little bit about the first one, the fact that you can kind of use the threat of arbitration to kind of get to the right decision makers. And in my experience, there are many countries have kind of a dedicated office that deals with these matters. Could you speak to that?
Sure. So I would say that bigger countries that are direct recipients of foreign direct investment have usually in let's say a justice department or an equivalent, a group of lawyers who are specialized in dealing with these treaty claims. So even though the lawyers, and I've spoken to some of them, I've had contact with them in Mexico, not because of visa, but in my prior experience, Mexico, Argentina, and Ecuador. And I mean, these lawyers at the end of the day, they want to advise their government, their client on what's the best course of action. I would say that they tend to be pragmatic if your case has merits, because they understand the cost of these claims, both in terms of money and resources, but also in terms of political capital. So if you do have a serious regulatory dispute or issue, those lawyers are usually, or that office is usually a good office to go to, because they will have the ear of the decision makers. And so your dispute may be, with a particular city, but if you go to this office, they may be able to call the mayor and say, hey, we have these international commitments. What you've done actually breaches them. And the solution that the foreign investor is proposing is actually quite easy to implement. So again, if the case is has merits and your proposed solution is fairly straightforward, then it's a good first port of call to resolve disputes. Now, if you're in the typical dispute that that foreign investors are kind of stereotyped, like in the energy sector, and we're talking about a direct expropriation of a multi-million-dollar or billion-dollar asset, going to that office, helps. But at the end of the day, the dispute really will probably continue, because it ends up being a more about, how much money are we going to pay you in compensation, rather than are you right or are you wrong. But for tech companies, it may be a more nuanced discussion that trained lawyers in government make sense to be the ones that you go to initially.
Yeah, I find having that entry point of the home office that's dedicated to investment arbitration to be very helpful. They tend to be quite sophisticated, and like you said, they can evaluate the merits, and so you're really talking to a counterpart with whom you can do business to some degree. I know Carlos has a comment, and so Carlos, if you'd like to make that, please go ahead. Otherwise,
thank you, Tom. I had a tech issue here that I got booted out, but apparently I'm back. Can you all hear me?
Yep. Yes.
Okay, good. No, I just wanted to add to Leon's remarks that typically a good opportunity or a good juncture to begin these negotiations with the sovereign, the country, is with the trigger letters. We all know that you got to send these trigger letters, these notifications to to the country or to the state saying that we intend to file a, NAFTA claim or any particular claim under a bilateral investment treaty. So those trigger points, those trigger letters are very important. And I think that it is a great opportunity that many of us should take more seriously. A lot of folks just simply, send the letters out and then wait their, required time frame, typically 90 days. It's the cooling off period. I think that it's a good opportunity, and I really encourage everybody to take use of that and take that and try to negotiate at that point. Once that train has left the station proceedings start, it's going to be a lot more difficult then than it is at the beginning with that trigger letter to try to resolve the case at that point.
Mm-hmm.
I can add to that, Tom, if I may.
Please do.
Yeah, I think sending a trigger letter is obviously an important step. But in our experience, what we've seen on various cases is not only sending a trigger letter, but substantiating, with a quantum analysis, a serious quantum analysis, your damages claim already from the get-go. I think it sends a very serious message to the state that you have looked into the actual quantum and that an independent expert has looked into it. And then you can really talk numbers a bit more quickly with the state. And we have found this helpful in terms of settling cases early on in our experience.
I like that very practical perspective. And I think it ties in nicely actually with Leon's third point, which was publicity, which in the United States, we've been sued over 20 times, but it doesn't tend to make headlines aside from cases like the Keystone Pipeline. Whereas in many countries, these cases make headlines, and there have even been situations where states have had to raise taxes in order to pay awards, and so people care deeply, and certainly the core point often is just how much is at risk. To go back to Andy's point about being very upfront about where you think the damages are going. Before we move on, Leon, I had one question for you. For many of us, the value of investment treaties is the idea that we can use them for leverage and negotiating. And do you agree with that view that they have the negotiating leverage, or do you more often see that you have to go through with the arbitration?
I think my answer is skewed because I used to be involved in carrying the arbitration through, right? So that's probably the most that I've seen. Now that I'm sort of client side, I would have to say that it would likely have to take a lot, a very severe regulatory change in order for a company to threaten treaty claims and actually try to negotiate with the government based on the treaty claims, because it is such a sort of rare, I think many times misunderstood and it's very difficult to predict sometimes how the government is going to react or what the outcome of the arbitration is going to be. So I would say, useful if you have good merits and more importantly, a proposed solution, whether it's, how much money you owe me, or, this regulation can be undone if you fix a single provision in it, right? Perhaps that would be helpful. But I guess I've mostly been involved in cases where the arbitration proceeds, right?
Mm-hmm. Yeah, and you may be able to speak to this, but I believe the majority of cases end up being resolved short of arbitration proceedings, though many do end up going through. And certainly, I think, Leon, you were drawing an important distinction in terms of the risk of actually going ahead with the arbitration and the circumstance. And I think the distinction being, is this a situation where whatever regulation has been levied against the company has either prevented the company from continuing to operate or has made it uneconomic for them to continue to operate? In that
Right.
circumstance, your risk of going ahead is much lower than your risk of, the situation where you're continuing to operate in country or you have people in country.
Yeah, and I mean, the other thing to point out is that when you're running the business, like your first concern is the business, right? Revenue generation or whatever you need to do for your shareholders. So when in a commercial dispute, in a commercial context, I think many times the business is even reluctant to enter into commercial dispute where the relationship needs to continue, even if you have the dispute. Here, the counterparty is a government, so your relationship must continue unless you divest, right? Or unless you're expropriated directly and you're forced to divest. So in most cases, there is that balancing act where where the business is always going to be wary of suing or even threatening to sue the people that actually control the rules to your business. And in some cases, technology companies are seeing around the world that those same regulators are also now starting to encroach in their commercial spaces and starting to compete with them directly. So even in the energy sector, like utility companies, but in the tech space, some governments are building their own tech systems that compete with government, with private company systems. So, it's challenging, again, because the regulator will have to be your counterparty throughout your business relationships in that country, and can also turn around and become a competitor. So it's challenging.
Right. Well, we'll move on, but my one point to wrap up, and that's simply, the value, I think, of having sophisticated offices in host states that understand treaties is that it allows you to kind of subtly indicate that you have that right to bring arbitration, or in fact they're just aware of it, and so that it allows you to negotiate in a way that does not necessarily require you to overtly threaten arbitration without them understanding that it is a tool in your toolbox. So why don't we move on to the dollars and cents, Annie? So in the event that we do elect to bring arbitration, how do investors finance these claims and then monetize the ultimate awards?
I think these disputes, DIT claims, usually entail a much greater level of complexity in terms of resources, process, and successfully recovering from the respondent state. And with this usually comes obviously higher risks and a hefty price tag. There's a recent Allen and Overy study that was published earlier this year. And according to that study, the average cost of a net investment treaty arbitration for a claimant alone is approximately $6 million if you see it through to the end. And this does not include, obviously, adverse cost exposure, costs of defending against setting aside proceedings or annulment proceedings, or enforcement costs if the state refuses to comply with the award. So on top of this heavy price tag, you have duration risk as well. The duration of an investor state arbitration is approximately 5 years to get to your final award. If you add to that, annulment or setting aside proceedings, then you need to add an additional year. And if the state, doesn't comply with the award, you might have to go into enforcement proceedings, which may last, depending on the state, between 2 to 4 years. And so unless the case settles early on, as we discussed about, and there are some statistics out there, ICSID has published its annual report, and once a case is launched against the state, they usually settle in about 10 to 15% of cases. So unless your case settles, your company will be registering a $6 million plus expense over the course of 5 to 9 years, depending if there are enforcement proceedings or not. So in this context, the decision of whether to launch or claim or not to protect your company's, business interests is ultimately a business decision, and dispute funding can help your management arrive to a yes by unlocking the upside potential of your claim and protecting your company against the downside risk of an unsuccessful outcome. And so let me explain to you what is dispute funding, if you're not aware. So under a typical funding arrangement, the funder would agree to meet all or an agreed portion of your legal costs and disbursements on a non-recourse basis. In other words, any return to the funder is dependent on the successful outcome of your claim. If your claim is unsuccessful, we lose our investment and you owe us absolutely nothing. So all of the financial and legal risk related to the case is on our shoulders. And we can be very flexible in terms of our funding package. I mentioned, the typical model, which is where we fund, the legal costs and disbursements, but we can also provide working capital for your business operations while the claim is ongoing, because we view arbitration, litigation, legal claims, as assets in and of themselves, out of which companies are able to leverage value by partnering with a funder. So once we decide to invest in a case, whether you are struggling to raise the sufficient funds to pursue a good claim or your company is well capitalized, what does that mean for you, concretely speaking? I think 5 things to remember. The first one, it leaves the business free to deploy, capital in its core operations. So instead of investing the $6 million I was referring to within, the arbitration, you're able to invest that $6 million elsewhere in the company for other profit generating projects. Second, it removes the legal fees from your company's P&L and it creates budget certainty. Third, it transfers the outcome risk to the funder, because payment of our investment and our return on investment is only made if the case is once and if the case is successful. And our objective is to leave, the majority of the recoveries to the client. For the next point, obviously, if we invest in a case and we lose the case, then that's not a good investment for us because we lose our investment. So we conduct a very thorough due diligence process. We have arbitration practitioners internally that will have a second look at your case and assess and test the case on jurisdiction, merits, and quantum to see where are its strengths and perhaps its weaknesses. So that is provided to you for free unless we invest in the case, obviously. And then, so we test the case on the merits, but what is also useful, and that depends on the funder you're partnering with, but at least at Omni Bridgeway, we have internally also asset tracers and enforcement specialists. So we also take a look at your recovery prospects. A state may pay willingly once you have obtained a successful award, but in many cases, a state won't pay willingly. And so what do we do at Omni Bridgeway, for example, when we assess, the recoveries prospect, and I think that's important in this particular context, we're going to look at first, who's the state and what is its payment capacity. We're going to look at the assets that are outside of the state that are owned by the state, whether they're subject to sovereign immunity or not, in which jurisdiction they are located, because in some jurisdictions it's easier to seize those assets than in other jurisdictions. We're going to look at whether there are other large award creditors that might go and try and seize the same assets that we would try to seize on behalf of our clients. And so in that sense, in the sense of payment capacity, I think there are few countries that we would not be prepared to go against, and that's our bread and butter at Omni Bridgeway. We have strong expertise in that field, but there are some countries that are more difficult than others. And so if there's a high enforcement risk, then obviously we want to make sure that on jurisdiction, merits, and quantum, your case is even stronger. So once we have identified assets that belong to the state outside of the state, we try and devise a coordinated legal strategy. Which assets are we going to try and seize? That may depend on the size of the assets. If the assets are huge, then usually, the phone will start ringing at some point in time. but it can, an asset can have low value, but high nuisance value. For example, we're working with a client that had obtained a successful award against an African state, and we managed to seize the presidential plane of that of the head of the state. Low value as an asset, but high nuisance because it made him look bad vis-a-vis his own people. And so once the plane had landed in a jurisdiction where we could seize easily, we made such application, we won that application, and a few days later, we got a phone call as well, and we managed to settle the claim. So those are kind of the factors we kind of look into when we assess recovery prospects against states. But in our experience, most cases on an enforcement level, at least, will be settled by the state, but usually with a certain discount. So you will not necessarily manage to obtain 100% of the value of your award, but you might have to discount it a little bit through negotiations with the state. Usually the typical discount might be around 20-25%, might be more, might be less, depending on the situation.
Right. And this is a world where fundamentally there isn't another recourse other than international arbitration. And so we're doing what we can. In the interest of time, I'm afraid we need to move on. I also need to give you all the CLE code, importantly. And the CLE code is a memorable one. It is technology, simply the word technology. That is our CLE code. Carlos, I'd like to come back to your point about claims. Can you give us a sense for the types of measures, government measures, that can trigger investment treaty claims?
Yes, and apologies for some of the tech issues. For once, my computer actually crashed. It had nothing to do with, the administrators of the program. It was my personal computer. It just, crashed. So, but I got another one. So, and this is got to have plan B. So yes, claims, causes of action. Let me talk about the following ideas to kind of give a sense of what are the claims that are covered by some of these treaties. The first one is, of course, the most favored nation treatment clause. And that's a concept that obligates the country to treat the investor no less favorably than it treats its own domestic citizens or the citizens of another contracting state. And that's a very good hammer, if you will, because even if the particular treaty under which the claimant is proceeding does not have the best remedies, if, however, that treaty has the MFN clause, most favored nation clause, then the state is theoretically obligated to incorporate another treaty that does have the more favorable remedies. And that's, of course, an important tool also. Another idea that these treaties cover too is what is typically called full protection and security remedy. And of course, as the name implies, it expressly includes physical security, but it's much more than that. It includes also legal security, commercial security, and it can also protect the investor against actors that are not directly connected to the sovereign state, which is always kind of a key here. You got to connect state action, if you will. You got to connect the bad conduct, to the actions of the government. This remedy many times includes other actors that are not directly connected to the state. Another remedy is what is referred to as the fair and equitable treatment remedy, and that's a very big concept. And again, these treaties they're written by policy wonks. They're written by politicians and bureaucrats. They're not. I mean, many are lawyers, but certainly they're not written in a contractual verbiage that we all know and love, or they're not statutes. They're very broad concepts, and so there's a lot of room for interpretation. But this one, fair and equitable treatment, is the cause of action or the remedy that is often invoked in a lot of these claims. And it's kind of like the most favored nation treatment claim, but it's not, it's broader, if you will. And that's certainly a good thing for the claimant. There are limits on expropriation that many apply to kind of an eminent domain concept, where if the government expropriates either directly or indirectly the investment, then there's got to be a fair procedural mechanism for doing so. There's got to be compensation. So these are the kinds of remedies or causes of action, Tom, that many of these bilateral investment treaties include.
Excellent. Maybe we could talk about a few examples just to kind of make this a bit more concrete. One that comes to mind in the tech sector is the recent threat of arbitration by Uber against Colombia. And there, I believe the fact pattern was that Colombia barred Uber from operating in the country because it was disrupting the local champions. And so this is a good example of a tech company being disruptive and as a result garnering some unwanted attention. And there, I believe the claim came under the fair and equitable treatment standard for discrimination. And there are others. Would you like to speak to any? Or
there's one that comes to mind. It's the case of Siemens versus Argentina. And I'm sure that some of the listeners and participants, forgive me if some of you participated in one capacity or another in this case, but it does come to mind because it's I think in many ways a kind of a classic example of government conduct that creates a claim under an international bilateral investment treaty, and that's a case where there was a treaty between Argentina and Germany, and pursuant to a bid solicitation process, the claimant went through the bid process, and essentially it was a contract for the provision of IT services. And the claimant was able to procure that award, signed up with the government to provide these IT services. And when they were ready to commence, the government said, well, we need to we put a pause on the commencement of the contract. Several pauses later, 4 or 5 pauses later, it became apparent, I think, to everybody that the government wanted to renegotiate the terms of the contract. In the midst of the renegotiations, the government passed legislation authorizing the president of the company, of the country, to unilaterally declare public service contracts unenforceable if he deemed it so necessary. And a few days after that legislation was passed, the president of the country, together with his ministers, communicated to the claimant that unless they signed the contract that the government wanted, that they were going to terminate, their relationship. Of course, the claimant did not, and pursued remedies under the treaty. And after years of litigation, there was an award in favor of the claimant for $238 million. And I won't get into the details, but it was a substantial award. Annulment proceedings were pursued later, which is, I think, as Annie knows well, is sometimes the case. And typically these annulment proceedings seek relief from the courts, claiming that the initial contract was procured by fraud by the claimant. And during the course of these proceedings, eventually the case settled, as Annie suggested earlier, probably for less than the amount of the claim. I don't know the award, the amount of the award. Nobody does. It's confidential. But that's essentially another example of conduct by the government that creates these kind of remedies.
Well, great. And in the interest of time, we'll move on. But there are a range of different cases, passed and pending by tech companies against sovereigns, including IBM on one end of the spectrum, Huawei on another. We're going to actually, Carlos and I will join the lunch groups at 1:30 Eastern, and so we can pick up on this conversation then. But in our closing minutes, I have a final question. I'm going to direct to Leon and Annie. So what issues, Leon, from your perspective, should in-house counsel be thinking about when assessing a potential treaty claim? And then Annie, I'm going to put similar question to you. What issues do you focus on when advising your credit committee on whether to go ahead with the claim? So,
okay, so in 1 minute, is, does it further our business goal? So what do we want to accomplish? What remedy, like within that topic of business goal, like what remedies are available? Do we want compensation or some sort of injunctive relief? So in other words, do we want money, or do we want the government to change a behavior or a regulation? Another area would be, is there a better alternative, right? Have we tried other alternatives and failed? Or a third one would be, how does it fit within a broader strategy to solve the dispute? So even if we're going to try to solve the dispute and bring up the treaty claim, are there other things we will do simultaneously to try to accomplish our goal? And the treaty claim, you know, sometimes it's best to have peace through war. So, I mean, I'm not making references to the current conflict, but I'm just saying, you know, if a case is pending, that is when you have the attention of authorities, and maybe that's when they're most willing to come to the table and settle. And then the last two would be obviously the how solid is your case? You know, do you have jurisdictions? Do you have merits? Quantum, like how much is your claim worth, and is the valuation of your claim solid? And how can it be challenged, and et cetera. The last point, so then I'll leave it up to Annie, is how much is this going to cost us, right? Very important for a company. And there are a lot of issues to consider with that. So with that, Annie, I'll give it over to you.
Leon, it may cost you nothing if you partner with a funder, at least not initially. It'll cost you down the road, because obviously we'll take a cut out of your award, but at least we'll take on the risk for you while the case is ongoing. So, but what we assess is, you know, very similar to what an in-house counsel would assess. Our investment committee will obviously will be interested in three things. The first one is, and I've discussed already, is, you know, realistic routes to recovery. And that I've discussed already. The second is obviously good prospects of success of the case on jurisdiction, merits, and quantum. We often are approached at a time where we don't even have, you know, a request for arbitration that has been drafted, and so it's a bit difficult sometimes to assess what a state will say in its defense. But we can, you know, Carlos alluded to corruption defenses. That's something we're very attuned to. You know, defenses on the merits, and obviously on quantum as well. What assumptions are they going to attack? Is this a realistic quantum assessment, etc. We also look at evidentiary risks as well. Sometimes, you know, if there's a key witness that is located in the states that we're going after, that might be tricky. The state might, you know, put political pressure on such person, and the person might refuse to testify. So if the case bears on that, I mean, that's something that's going to be very important for us to look into. Yeah. So those are the types of risks we're looking for on the merits. And then finally, you know, for us, it's a business decision. Is this a good investment or not? So on the financials, that's something very important. So we look at obviously the budget. How much are we being asked to invest in this case? Is this a realistic budget? Do we anticipate that we're going to need more money because we're going to need a local counsel, or we're going to need an extra expert, an industry expert to testify as well? And so we try to shore up the budget and make sure that it's a realistic budget, and we work with clients and counsel on that. The second thing we look at is obviously quantum. Is this a realistic quantum assessment of the case? Again, the Allen and Overy study I referred to earlier mentions that in investor state disputes, tribunals usually on average award 36% of claimed damages. So that's something that we're tuned to. We'll look at what is the, you know, quantum theory, what is the valuation methodology, whether the assumptions make any sense in the DCF model, for example. So those are things we'll look at. And then it's we look at the proportionality between, you know, the realistic claim value But it's not only the claim value, it's actually the actual size of potential recoveries. You'll remember I discussed this potential discount we'll get at the
Right.
end. The state might not pay 100%. And then we compare that to the total amount of funding which is being sought, and we want to make sure that the financial pie is big enough at the end of the road so that everybody's financial appetite is satisfied, not only ours and the lawyers, if the lawyers have taken on risk, but also the clients. We want the client to have the majority of the recovery. So we look for a ratio between 1 to 10. And then finally, I know it's past 2 minutes, but finally the duration risk, obviously. We do stress tests if this is going to take 9 years, if this is going to take 5 years, what does that mean for our internal rate of return? So those are the things we look at.
Well, thank you. I'm afraid we've run out of time for questions. Please bring them to the lunch hour. I apologize to Alan and Catherine. We didn't get to their questions in the chat boxes. I will definitely do so at 1:30. Thank you, Annie, Leon, Carlos, for your perspectives on how tech companies can make use of investment treaties to mitigate their risks. It's a pleasure.
Thank you, Tom.
Thank you, Tom.
Thanks, Tom. And thanks, Leon.
Enjoy the rest of the
Carlos.
conference, everyone.
Bye-bye.